Chapter 11 Deaths. Art. 129. The wills of internees shall be received for safekeeping by the responsible authorities, and in the event of the death of an internee his will shall be transmitted without delay to a person whom he has previously designated. Deaths of internees shall be certified in every case by a doctor, and a death certificate shall be made out, showing the causes of death and the conditions under which it occurred. An official record of the death, duly registered, shall be drawn up in accordance with the procedure relating thereto in force in the territory where the place of interment is situated, and a duly certified copy of such record shall be transmitted without delay to the protecting power as well as to the central agency referred to in Article 140. Art. 130. The detaining authorities shall ensure that internees who die while interned are honorably buried, if possible according to the rites of the religion to which they belonged, and that their graves are respected, properly maintained, and marked in such a way that they can always be recognized. Deceased internees shall be buried in individual graves unless unavoidable circumstances require the use of collective graves. Bodies may be cremated only for imperative reasons of hygiene, on account of the religion of the deceased or in accordance with his expressed wish to this effect. In case of cremation, the fact shall be stated and the reasons given in the death certificate of the deceased. The ashes shall be retained for safekeeping by the detaining authorities and shall be transferred as soon as possible to the next of kin on their request. As soon as circumstances permit, and not later than the close of hostilities, the detaining power shall forward lists of graves of deceased internees to the powers on whom the deceased internees depended through the information bureaus provided for in Article 136. Such lists shall include all particulars necessary for the identification of the deceased internees, as well as the exact location of their graves. Art. 131. Every death or serious injury of an internee caused or suspected to have been caused by a sentry, another internee, or any other person, as well as any death the cause of which is unknown, shall be immediately followed by an official inquiry by the detaining power. A communication on this subject shall be sent immediately to the protecting power. The evidence of any witnesses shall be taken, and a report including such evidence shall be prepared and forwarded to the said protecting power. If the inquiry indicates the guilt of one or more persons, the detaining power shall take all necessary steps to ensure the prosecution of the person or persons responsible. Chapter 12 Release, Repatriation, and Accommodation in Neutral Countries. Art. 132. Each interned person shall be released by the detaining power as soon as the reasons which necessitated his internment no longer exist. The parties to the conflict shall, moreover, endeavor, during the course of hostilities, to conclude agreements for the release, the repatriation, the return to places of residence or the accommodation in a neutral country of certain classes of internees, in particular children, pregnant women and mothers with infants and young children, wounded and sick, and internees who have been detained for a long time. Art. 133. Internment shall cease as soon as possible after the close of hostilities. Internees in the territory of a party to the conflict, against whom penal proceedings are pending for offenses not exclusively subject to disciplinary penalties, may be detained until the close of such proceedings and, if circumstances require, until the completion of the penalty. The same shall apply to internees who have been previously sentenced to a punishment depriving them of liberty. By agreement between the detaining power and the powers concerned, committees may be set up after the close of hostilities or of the occupation of territories to search for dispersed internees. Art. 134. The high contracting parties shall endeavor, upon the close of hostilities or occupation, to ensure the return of all internees to their last place of residence, or to facilitate their repatriation. Art. 135. The detaining power shall bear the expense of returning released internees to the places where they were residing when interned, or, if it took them into custody while they were in transit or on the high seas, the cost of completing their journey or of their return to their point of departure. Where a detaining power refuses permission to reside in its territory to a released internee who previously had his permanent domicile therein, such detaining power shall pay the cost of the said internee's repatriation. If, however, the internee elects to return to his country on his own responsibility or in obedience to the government of the power to which he owes allegiance, the detaining power need not pay the expenses of his journey beyond the point of his departure from its territory. The detaining power need not pay the costs of repatriation of an internee who was interned at his own request. If internees are transferred in accordance with Article 45, the transferring and receiving powers shall agree on the portion of the above costs to be borne by each. The foregoing shall not prejudice such special agreements as may be concluded between parties to the conflict concerning the exchange and repatriation of their nationals in enemy hands. Hands. Section V. Information Bureaus and Central Agency Art. 136. Upon the outbreak of a conflict, and in all cases of occupation, each of the parties to the conflict shall establish an official information bureau responsible for receiving and transmitting information in respect of the protected persons who are in its power. Each of the parties to the conflict shall, within the shortest possible period, give its bureau information of any measure taken by it concerning any protected persons who are kept in custody for more than 2 weeks, who are subjected to assigned residence, or who are interned. It shall, furthermore, require its various departments concerned with such matters to provide the aforesaid Bureau promptly with information concerning all changes pertaining to these protected persons, as, for example, transfers, releases, repatriations, escapes, admittances to hospitals, births, and deaths. Art. 137. Each national bureau shall immediately forward information concerning protected persons by the most rapid means to the powers of whom the aforesaid persons are nationals, or to powers in whose territory they resided, through the intermediary of the protecting powers, and likewise through the central agency provided for in Article 140. The bureaus shall also reply to all inquiries which may be received regarding protected persons. Information bureaus shall transmit information concerning a protected person unless its transmission might be detrimental to the person concerned or to his or her relatives. Even in such a case, the information may not be withheld from the central agency which, upon being notified of the circumstances, will take the necessary precautions indicated in Article 140. All communications in writing made by any bureau shall be authenticated by a signature or a seal. Art. 138. The information received by the National Bureau and transmitted by it shall be of such a character as to make it possible to identify the protected person exactly and to advise his next of kin quickly. The information in respect of each person shall include at least his surname, first names, place and date of birth, nationality, last residence and distinguishing characteristics, the first name of the father and the maiden name of the mother, the date, place, and nature of the action taken with regard to the individual, the address at which correspondence may be sent to him, and the name and address of the person to be informed. Likewise, information regarding the state of health of internees who are seriously ill or seriously wounded shall be supplied regularly and if possible every week. Art. 139. Each National Information Bureau shall, furthermore, be responsible for collecting all personal valuables left by protected persons mentioned in Article 136, in particular those who have been repatriated or released, or who have escaped or died. It shall forward the said valuables to those concerned, either direct, or, if necessary, through the central agency. Such articles shall be sent by the Bureau in sealed packets which shall be accompanied by statements giving clear and full identity, particulars of the person to whom the articles belonged, and by a complete list of the contents of the parcel. Detailed records shall be maintained of the receipt and dispatch of all such valuables. Art. 140. A central information agency for protected persons, in particular for internees, shall be created in a neutral country. The International Committee of the Red Cross shall, if it deems necessary, propose to the powers concerned the organization of such an agency, which may be the same as that provided for in Article 123 of the Geneva Convention relative to the treatment of prisoners of war of August 12, 1949. The function of the agency shall be to collect all information of the type set forth in Article 136 which it may obtain through official or private channels, and to transmit it as rapidly as possible to the countries of origin or of residence of the persons concerned, except in cases where such transmissions might be detrimental to the persons whom the said information concerns, or to their relatives. It shall receive from the parties to the conflict all reasonable facilities for effecting such transmissions. The high contracting parties, and in particular those whose nationals benefit by the services of the central agency, are requested to give the said agency the financial aid it may require. The foregoing provisions shall in no way be interpreted as restricting the humanitarian activities of the International Committee of the Red Cross and of the relief societies described in Article 142. Art. 141. The National Information Bureaus and the Central Information Agency shall enjoy free postage for all mail, likewise the exemptions provided for in Article 110, and further, so far as possible, exemption from telegraphic charges or, at least, greatly reduced rates.